Part 2. This is a powerful letter from the Department of Justice to all courts receiving federal funds, which is every single one. I filed a copy of this letter in my case for a due process violation, and it was dismissed next time I went to court. I've seen people use it to get out of jail for back child support, and it can be used for many other cases. Let's finish seeing what it says. So listen close. Third, courts must not condition access to a judicial hearing on prepayment of fines or fees. State and local courts deprive indigent defendants of due process and equal protection if they condition access to the courts on payment of fines or fees. See Body v. Connecticut, 401 U.S. 371, 374, 1971, holding that due process bars states from conditioning access to non-governmental compulsory judicial process on the payment of court fees by those unable to pay. See also Tucker v. City of Montgomery, Board of Commissioners, 410F Sup 494502, M. Diala, 1976, holding that the conditioning of an appeal on payment of a bond violates indigent prisoners' equal protection rights and has no place in our heritage of equal justice under law. This unconstitutional practice is often framed as a routine administrative matter. For example, a motorist who is arrested for driving with a suspended license may be told that the penalty for the citation is $300 and that a court date will be scheduled only upon the completion of a $300 payment, sometimes referred to as a pre-hearing bond or bail payment. Courts most commonly impose these prepayment requirements on defendants who have failed to appear, depriving those defendants of the opportunity to establish good cause for missing court. Regardless of the charge, these requirements can have the effect of denying access to justice to the poor. Fourth, courts must provide meaningful notice and, in appropriate cases, counsel. When enforcing fines and fees, an elementary and fundamental requirement of due process in any proceeding which is to be accorded finality is notice reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. Mullane v. Sent. Hanover Bank and Trust Company, 339 U.S. 306, 314-15, 1950. See also Turner, 131 S. Sacker at 2519, discussing the importance of notice in proceedings to enforce a child support order. Thus, constitutionally adequate notice must be provided for even the most minor cases. Courts should ensure that citations and summonses adequately inform individuals of the precise charges against them, the amount owed or other possible penalties, the date of their court hearing, the availability of alternate means of payment, the rules and procedures of court, their rights as a litigant, or whether in-person appearance is required at all. Gaps in this vital information can make it difficult, if not impossible, for defendants to fairly and expeditiously resolve their cases. And inadequate notice can have a cascading effect, resulting in the defendant's failure to appear and leading to the imposition of significant penalties in violation of the defendant's due process rights. Further, courts must ensure defendants' right to counsel in appropriate cases when enforcing fines and fees. Failing to appear or to pay outstanding fines or fees can result in incarceration, whether through the pursuit of criminal charges or criminal contempt, the imposition of a sentence that had been suspended, or the pursuit of civil contempt proceedings. The Sixth Amendment requires that a defendant be provided the right to counsel in any criminal proceeding resulting in incarceration. See Scott v. Illinois, 440 U.S. 367, 373, 1979, Argersinger v. Hamlin, 407 U.S. 25, 37, 1972, and indeed forbids imposition of a suspended jail sentence on a probationer who was not afforded a right to counsel when originally convicted and sentenced. 5. The Supreme Court reaffirmed this principle in Little v. Streeter, 452 U.S. 1, 16-17, 1981, when it prohibited conditioning indigent persons access to blood tests and adversarial paternity actions on payment of a fee, and in MLB v. SLJ, 519 U.S. 102-107, 1996, when it prohibited charging filing fees to indigent persons seeking to appeal from proceedings terminating their parental rights. ஐந்தாவது, see Alabama v. Shelton, 535 U.S. 654, 662, 2002. Under the 14th Amendment, defendants likewise may be entitled to counsel in civil contempt proceedings for failure to pay fines or fees. See Turner, 131 South Court at 2518-19, holding that although there is no automatic right to counsel in civil contempt proceedings for non-payment of child support, due process is violated when neither counsel nor adequate alternative procedural safeguards are provided to prevent incarceration for inability to pay. Aravde. 5. Courts must not use arrest warrants or license suspensions as a means of coercing the payment of court debt when individuals have not been afforded constitutionally adequate procedural protections. The use of arrest warrants as a means of debt collection, rather than in response to public safety needs, creates unnecessary risk that individuals' constitutional rights will be violated. Warrants must not be issued for failure to pay without providing adequate notice to a defendant, a hearing where the defendant's ability to pay is assessed, and other basic procedural protections. See Turner, 131 South Court at 2519, Bearden, 461 U.S. at 671-72, Mullane, 339 U.S. at 314-15. When people are arrested and detained on these warrants, the result is an unconstitutional deprivation of liberty. Rather than arrest and incarceration, courts should consider less harmful and less costly means of collecting justifiable debts, including civil debt collection. Yeram. In many jurisdictions, courts are also authorized and in some cases required to initiate the suspension of a defendant's driver's license to compel the payment of outstanding court debts. If a defendant's driver's license is suspended because of failure to pay a fine, such a suspension may be unlawful if the defendant was deprived of his due process right to establish inability to pay. See Bell v. Burson, 402 U.S. 535, 539, 1971, holding that driver's licenses may become essential in the pursuit of a livelihood and thus are not to be taken away without that procedural due process required by the 14th Amendment. Dixon v. Love, 431 U.S. 105, 113-14, 1977, upholding revocation of driver's license after conviction based in part on the due process provided in the underlying criminal proceedings. Mackey v. Montrim, 443 U.S. 1, 13-17, 1979, upholding suspension of driver's license after arrest for driving under the influence and refusal to take a breath analysis test because suspension substantially served the government's interest in public safety and was based on objective facts either within the personal knowledge of an impartial government official or readily ascertainable by him, making the risk of erroneous deprivation low. Accordingly, automatic license suspensions premised on determinations that fail to comport with Bearden and its progeny may violate due process. 6. Turner's ruling that the right to counsel is not automatic was limited to contempt proceedings arising from failure to pay child support to a custodial parent who is unrepresented by counsel. See 131 South Court at 2512-2519. The court explained that recognizing such an automatic right in that context could create an asymmetry of representation. Idnos at 2519. The court distinguished those circumstances from civil contempt proceedings to recover funds due to the government, which more closely resemble debt collection proceedings in which the government is likely to have counsel or some other competent representative. Identification at 2520. 7 researchers have questioned whether the use of police and jail resources to coerce the payment of court debts is cost-effective. See, e.g., Catherine Beckett and Alexis Harris, On Cash and Conviction, Monetary Sanctions as Misguided Policy, 10C Reminology, and PUB. POLY 505-527-28, 2011. This strategy may also undermine public safety by diverting police resources and stimulating public distrust of law enforcement. Even where such suspensions are lawful, they nonetheless raise significant public policy concerns. Research has consistently found that having a valid driver's license can be crucial to individuals' ability to maintain a job, pursue educational opportunities, and care for families. 8. At the same time, suspending defendants' licenses decreases the likelihood that defendants will resolve pending cases and outstanding court debts, both by jeopardizing their employment and by making it more difficult to travel to court, and results in more unlicensed driving. For these reasons, where they have discretion to do so, state and local courts are encouraged to avoid suspending driver's licenses as a debt collection tool, reserving suspension for cases in which it would increase public safety. Devyati. 6th, courts must not employ bail or bond practices that cause indigent defendants to remain incarcerated solely because they cannot afford to pay for their release. When indigent defendants are arrested for failure to make payments they cannot afford, they can be subjected to another independent violation of their rights: prolonged detention due to unlawful bail or bond practices. Bail that is set without regard to defendants' financial capacity can result in the incarceration of individuals not because they pose a threat to public safety or a flight risk, but rather because they cannot afford the assigned bail amount. As the Department of Justice set forth in detail in a federal court brief last year, and as courts have long recognized, any bail practices that result in incarceration based on poverty violate the 14th Amendment. 10 systems that rely primarily on secured monetary bonds without adequate consideration of defendants' financial means tend to result in the incarceration of poor defendants who pose no threat to public safety solely because they cannot afford to pay. 11. To better protect constitutional rights while ensuring defendants' appearance in court and the safety of the community, courts should consider transitioning from a system based on secured monetary bail alone to one grounded in objective risk assessments by pre-trial experts. A study of suspended drivers in New Jersey, which found that 42% of people lost their jobs as a result of the driver's license suspension, that 45% of those could not find another job, and that this had the greatest impact on seniors and low-income individuals. 9C American Association of Motor. Administrators, Best Practices Guide to Reducing Suspended Drivers, recommending that legislatures repeal state laws requiring the suspension of driving privileges for non-highway safety-related violations, and citing research supporting view that fewer driver suspensions for non-compliance with court requirements would increase public safety. Permitting pre-trial detention in the federal system when no conditions will reasonably assure the appearance of the defendant and safety of the community, but cautioning that the judicial officer may not impose a financial condition that results in the pre-trial detention of the person. 7. Courts must safeguard against unconstitutional practices by court staff and private contractors. In many courts, especially those adjudicating strictly minor or local offenses, the judge or magistrate may preside for only a few hours or days per week, while most of the business of the court is conducted by clerks or probation officers outside of court sessions. As a result, clerks and other court staff are sometimes tasked with conducting indigency inquiries, determining bond amounts, issuing arrest warrants, and other critical functions, often with only perfunctory review by a judicial officer or no review at all. Without adequate judicial oversight, there is no reliable means of ensuring that these tasks are performed consistent with due process and equal protection. Regardless of the size of the docket or the limited hours of the court, judges must ensure that the law is followed and preserve both the appearance and reality of fairness, generating the feeling so important to a popular government that justice has been done. Additional due process concerns arise when these designees have a direct pecuniary interest in the management or outcome of a case. For example, when a jurisdiction employs private for-profit companies to supervise probationers. In many such jurisdictions, probation companies are authorized not only to collect court fines, but also to impose an array of discretionary surcharges, such as supervision fees, late fees, drug testing fees, etc., to be paid to the company itself rather than to the court. Thus, the probation company that decides what services or sanctions to impose stands to profit from those very decisions. The Supreme Court has always been sensitive to the possibility that important actors in the criminal justice system